Now moving on to the next set of judicial remedies. Remember, we were talking about civil cases before the National Green Tribunal. However, there are several statutory violations or violations of environmental law provisions which constitute criminal offences. Now, complaints with regard to these offences have to be filed in a criminal court by appropriate government agencies. Now, let us look at some of the examples of criminal offences. Let us look at the Water Prevention and Control of Pollution Act of 1974 and the Air Prevention and Control of Pollution Act of 1981, which are popularly known as the Water Act and the Air Act. Under these acts, there are certain offences that, if committed, complaints have to be filed in the criminal court. Now, what could be an example of a criminal offence under the Water Act? It could be that a consent to establish has not been granted, yet an industry has started functioning. Another example could be that a consent has been granted and certain standards have been placed on the quality and the amount of discharge that can be allowed from an industrial plant into the stream. What is the effluence that's permitted? However, the industry violates these standards or goes beyond these standards, this would also be an environmental offence. If such kind of offences or illegal activities take place, then the concerned State Pollution Control Board, the Pollution Control Board of the state in which these offences take place, has to file a complaint either in the court of the Metropolitan Magistrate or the Judicial Magistrate First Class, but not in a court inferior to these magistrates. A private citizen, someone who is not part of the State Pollution Control Board, can also file a complaint against such an environmental offence. However, such a person would have to give a 60-day notice to the State Pollution Control Board of its intention, of his or her intention to file such a complaint in the Metropolitan Magistrates Court and the reasons or the alleged offences based on which this criminal complaint is going to be filed. And he has to give this notice for 60 days, after which he or she can approach the court. Another example could be of the Wildlife Protection Act. There are several offences under the Wildlife Protection Act which are actually criminal in nature. Examples of that would be hunting of protected species, illegal trade, smuggling or poaching of animal parts, body parts or meat or skin or hair, which is commonly traded, however illegally. All these are criminal offences, and complaints may be filed by designated government agencies such as the Chief Wildlife Warden, the Director of the Zoo, or the Director of the Tiger Reserve. These designated government agencies can file the case in the relevant criminal court. A private citizen, again, can also file a criminal case under the Wildlife Protection Act. However, he or she has to give 60 days notice to the central government of his or her intention to file such a criminal case and the alleged offence against which such a criminal case is being filed. Now we come to the third set of judicial remedies that are available to people in the form of the higher judiciary in the country. The higher judiciary is the Supreme Court of India and the high courts in all the states of the country. Now the higher judiciary plays an extremely important role and has historically played a very important role in environmental cases. As you must have read in other modules, the Article 21 of the Constitution, which guarantees the right to life, has been interpreted on several occasions to include the right to clean and healthy environment. Now the Supreme Court and the High Court have used this as the basis to engage in environmental cases before them. Under Article 32 of the Constitution, every person in this country has a fundamental right to approach the Supreme Court for violation of his or her fundamental right, and this includes the fundamental right to clean and healthy environment. What does this mean? It means that if my fundamental right to clean and healthy environment has been violated, I actually have a fundamental right under the Article 32 to approach the Supreme Court. And no law in this country, no law passed by the Parliament or the state legislature can take away my right to approach the Supreme Court. However, as you can imagine, the Supreme Court cannot be inundated with all sorts of environmental cases. So the Supreme Court is only likely to hear cases which involve issues across state boundaries, where several states are engaged or illegalities have been committed in several states, or the issue is of immense national importance, or of course if it has come in appeal from a decision of a high court. If there is any other court such as the National Green Tribunal or the High Court of the concerned state, if the Supreme Court thinks that these courts provide an alternative and efficacious, which means a good effective remedy, then the Supreme Court will require the petitioner to approach either the National Green Tribunal or the High Court instead of directly coming to the Supreme Court itself. Now, the High Courts can be approached under the Article 226 of the Constitution of India. Under Article 226, it need not just be a violation of a fundamental right of a person or an organization, but could also be a violation of any other statutory right or the lack of enforcement of a particular statutory obligation. The higher judiciary, the Supreme Court and the High Courts, have a wide powers in what kind of directions they can give in environmental cases. So they can certainly direct payment of compensation, requirement for restitution of the environment, restoration of damaged property. They can also direct the conduct of assessment studies, direction to undertake inspections, directions to state governments or other government agencies to comply with statutory directions or requirements, and they can also enforce the rights of people approaching them, which means that if they believe that the fundamental right or any other right of people approaching them has actually been violated or restricted in any way, they can give whatever appropriate directions in the form of orders, judgments and writs to ensure that these rights are protected. Now, occasionally these writ petitions that are filed under Article 226 of the before the High Court and Article 32, as I mentioned before the Supreme Court, take the form of what are called public interest litigations, or PILs. Now, PILs are a little different in nature because very often they are filed by people who are not directly affected, but on behalf of people who are affected but are unable to approach the court due to either social reasons, or they are too poor, or they are not able to reach due to certain cultural encumbrances. So for these reasons, some groups of people are not able to approach the court, and so their voice is voiced before the court in the form of public interest litigation. These public interest litigations are also typically with regard to massive environmental degradation which affects thousands of people. Several actors, several industries are involved, and it requires a thorough and long-term engagement of the courts in deciding or coming to any possible conclusion. And very often it is seen that the Supreme Court and the High Courts, even after they have given their final judgment, they continue to monitor the compliance of their orders to ensure that people are effectively able to enjoy their fundamental right to clean and healthy environment. Now, let us look at some of the examples of cases where the Supreme Court has played a very important role in protecting the environment. It could be in the 1980s, there was rampant and illegal quarrying of limestone in the Dehradun Valley, which was finally brought to an end through a series of orders coming from the Supreme Court. Another example could be the pollution caused by tanneries in Kanpur and in Kolkata, and in industries in Vellore in Tamil Nadu. All these cases of industrial pollution which had huge environmental impacts affecting the lives of thousands of people and damaging property and livelihoods worth crores of rupees have been addressed by Supreme Court and the High Courts through various orders and judgments to bring some reprieve, to give some remedy to people. Currently, some of the cases that are before the Supreme Court is that of illegal mining. For example, Belari mining, where a lot of iron ore mining was taking place illegally, leading to irreversible environmental degradation in the area. Mining in Goa, sand mining across the country. Also, there's a case with regard to the death of elephants on railway tracks in the northeastern states. So there are several cases with regard to forests, wildlife, environmental protection, which are currently being heard by the Supreme Court, which is constantly giving orders and monitoring the implementation of its orders. Now, I'd like to conclude today's discussion by emphasizing the important role played by the judiciary in democracy. It's really the third pillar in a democracy, along with the executive and the judiciary. And in India, they play the critical role of checks and balances and ensure that the executive and the legislature do their job properly, that they do not in any way hamper the rights of the people, and that people of this country are able to enjoy and live in an environment which is pollution free, hygienic, clean, and they are not affected, their health and lives are not affected by environmental degradation. People's rights and interests have to be given this form of legal protection in any democracy, particularly if they are backward communities such as tribal communities, people living in vulnerable areas such as islands and coastal communities. These communities and their interests have to be given particular importance before the judiciary. I'll end today's discussion by quickly summarizing what we have discussed so far in today's module on judicial remedies in environmental cases. We began by looking at the National Green Tribunal, which is a specialized court looking at environmental cases, and discussed its jurisdiction or the kind of cases that it can hear, starting from original jurisdiction and the appellate jurisdiction. We talked about what kind of orders can the National Green Tribunal give. Then we moved on to the kind of cases or the environmental offences which can be prosecuted in the criminal courts of the country, and we discussed examples under the Water Act and the Air Act and the Wildlife Protection Act. And we finally moved on to the higher judiciary, which can be approached through the writ petitions which may be filed under Article 32 and Article 226 of the Constitution before the Supreme Court and the High Courts respectively, and the kind of orders that these courts can give to give some reprieve to people affected by environmental decision making, particularly in public interest litigations and cases bringing out rampant and massive scale of environmental degradation. Thank you, and I hope you enjoyed today's session and learned something out of it.